We're on the record in the case of Cherokee versus Shaw, case number D565672. Your appearances.
Joe Houston, bar number 1440 for Mr. Cherokee, who's present.
Thank you.
Good afternoon, Your Honor. Doug Crawford on behalf of Tashara Shaw, bar number 181.
Hi, this is the court in Las Vegas.
And she's going to be present by phone.
Okay.
Also at council table is my paralegal, Brian.
Thank you. So we are here today on the defendant's motion to set aside or vacate an order of July 5th, 2018, and to stay enforcement of that order. And I have an opposition to that. Have council reached any agreements?
We had some discussion in the hallway. There doesn't seem to be much room for negotiation. It's their position that they're immediately entitled to custody. It's our position that they're not. And so I think, but I have some suggestions with respect to a timeshare. So it's our position that that service was invalid. Service by publication is valid if there's no knowledge of where the opposing party is. It's our position that he always had knowledge where she was. They were in contact by telephone. And Mr. Houston correctly pointed out in the hallway that just because we showed phone calls doesn't mean that there was knowledge about where she was located. But our client tells us that, in fact, she did tell him. He knew exactly where she was. For part of the time, she was in Cleveland at her father's house, a location that he's been to many times. And he knew she was at her father's house, so he could have served her there, but he didn't. Then she moved to Phoenix because she got a job there, and they were in contact on the phone several times a month during that time. So it's our position that service was invalid. The resulting custody order is not based upon any facts. It's based upon his version only. So it's basically our position that he had very little contact with the child at all for the first 3 years of her life. From the last year, for the last several years, he's had kind of sporadic contact, at best a couple of weekends a month, but often several month period when he didn't have any contact at all. So her position would be as follows. She is 8.5 months pregnant, which is why she couldn't be here today. The child is enrolled in school in Phoenix and starts school on Monday with the parent-teacher conference on Friday. She has no objection to him having some time with the child, and she is encouraging that. My suggestion would be that we send the parties to mediation, give Dad some immediate contact with the child, and that could be something like, unfortunately, Friday to Sunday, and then every other weekend from there, pending the FMC return, and then maybe a more solid long-distance timeshare could be reached. But to grant him custody based upon this essentially default ruling, it's our position that that's not what the Supreme Court had in mind when they talk about a fair and factual recitation. So, and as soon as he got her served, as soon as the publication, as soon as he got the order, the day after the order, he immediately got it to her that day. So he knew where she was. He was able to get her that order within 1 day. But all he's saying is he couldn't serve her with the moving papers before that. So that's essentially our position. Let's set it for mediation, give Dad some contact, and then set the matter for, if we have to, for evidentiary hearing, and we can fully flesh out what's in the best interest of the child. It's not in the best interest of the kid to just thrust her immediately with someone who she's only had sporadic contact with.
I like their argument that he's only had sporadic contact, but the reason he's only had contact over the last 8 months is because on December 1st, exactly 8 months ago, she took off from the state of Nevada, and he hasn't seen his child since. He's tried to contact her. He can't contact her by phone, and as we put in our pleadings, he can't contact her by phone because his phone's blocked. That doesn't show someone wanting to allow him contact. In all their pleadings, and they knew, we said we didn't know where she was, and Mr. Crawford said, publication is proper when we don't know where she was. There's not one thing they have showing, one email, anything, showing she ever gave him an address since December 1st. After she left on December 1st, he did contact her dad because he's friendly with her dad. And her dad's in Ohio. Her dad said no. I think she moved back to Ohio, but I don't know where she's at. She's not living here. She's living in some other city. There's not one document, one anything, one school record, one anything showing she was living with her father, even though that was what she's supposedly going to be her position. There's not one document to say that. So it's true even now, except there's an FDF that I received today or yesterday that had an address in it because it's got a pay stub. But I asked Mr. Crawford when this was there, I sent him 2 letters. Where's your client living? My client in December sent, which we have a document of, sent a letter, email to her because he had her email address. Where are you at? So if he knew where she at, why is he writing her email December 21st saying, I'm going to be in Ohio. If you're there, I'd like to see my child. And there's no response whatsoever to that email. He never gets to see his child. And Mr. Crawford, her position, and I won't say it's his position because he's just reciting what she says. In her pleadings, she says, Tashar's last known address, that we said Tashar's last known address was 5035 Auburn Skyline Street, Las Vegas, because he had discovered that she had come back in January for a couple of months. He discovered that. And so she says in her pleadings, and that's what we put in our publication, that's his last known address. In their pleadings, they say the 5035 Scarborough address is the address of her former boyfriend. She's never lived at that address. In another part of her affidavit, she says Tashara denies returning to Las Vegas in January of 2018. So there's actually another place. So 3 different times she alleges in her pleadings she never came back here once she left. She was in Ohio, just like Mr. Crawford said, and then she went to Phoenix. That is a lie. Our exhibit 1 is a copy, exhibit 2 is a copy of the Clark County School District records for her son, showing that he attended kindergarten here at one school, attended first grade up until December 1st when he got pulled out, and then showing that he came back and attended another school from January, first part of January through December or February 28th. And the address, which she set forth, not my client, because he didn't know they were even back. The address she sets forth and that she gave the school district was the 5035 Auburn Skyline address, which we did attempted service on. So there is no procedural due process here at all. We emailed her a copy of the pleadings as required. There's a certificate in there that my secretary did that. There's a certificate saying we mailed it to her father, and there's nothing here from her father saying, yeah, I got this and I didn't give it to her, or I got this and I did give it to her. There's nothing they got from her father, who supposedly she has lived with for months. There's not one thing from him. So she absolutely misrepresented to you that she didn't come back for 2 months, which she did. And our documents from the Clark County School District shows that. So she has no credibility. And there isn't one document showing she ever told him where she was at, any address, even though I've asked Mr. Crawford twice for that and never got even that information. So we believe the order was appropriate. We didn't know where she was. Her last known address was what we set forth because our own Clark County School District records show that. We published as we were required to do, and she decided not to come. Okay, like, hey, they don't have me. I'll just say I didn't get it. I don't know what is her mind, but she decided not to come. You enter a valid order, which gives my client temporary custody, with the idea being, yeah, at some point in time we'll have a full hearing on this. But for my client not to have custody for 8 months, and you now, as Mr. Crawford wants to do, say, well, we'll give him 2 days because the kid's going to start school next week sometime, is ridiculous. Your order should be enforced. He should be granted custody of his child, and then we should set an evidentiary hearing on what we're going to do from there. The documents which we even have filed, he did not give her, and And when he said he knew where she was because she sent him an email, okay, he didn't, first off, the order was entered July 5th by you. He didn't send her anything till 11 days later letting her know about the order because he hired a private investigator trying to find where she was and trying to find out where she was. And the private investigator, after 11 days, came up with nothing. And so the private investigator, who's been law enforcement, said, well, we can get the FBI involved, but you should at least send her something of the email showing her the order, because then we can say she's not complying with it. So on July 16th, 11 days later, he sent her a copy of that email, again, not knowing where she was, what state she was in, anything, having no idea where she was. And he's never had an idea where she was, and I don't know if these addresses she's even at these addresses, which are because there's 2 different addresses even in the 3 pay stubs she was attached. So we believe we did properly comply with statute. The records show, we've prevented from the school district show she's absolutely lying, intentionally misrepresented to the court, that she came back here. We properly served her at the last address, or tried to had an actual server, and we mailed to that address that she was at. And the court should enforce its order, which is in effect, and allow him to have his child. And what's really disgusting is that she alleges when she took off that she did it for financial reasons. But the text we have from her to her brother, who was supposed to watch the child the night before she took off, it says, yeah, Alex pissed me off, so we're in Cleveland. I quit my job. And she says he's unemployed. Well, no, in this email, she says she quit her job. Also, she says there's not one thing bad about him towards the child. And she says she does not wish, this is where it's just a joke and disgusting to me, she does not wish to keep Ava from Alex. She knows that Ava misses Alex and wants to see him. And she will comply with any order and produce the child. She hasn't done any of those. She hasn't let him see the child or have contact, even though he's asking for it over and over again. And he can't even call and speak to her then because his phone's blocked, his girlfriend's phone's blocked, his work phone's blocked, his brother's phone's blocked. They're all blocked. And there's no way for him to contact her. A few times, the child apparently probably said, I want to call Dad, I want to call Dad. So there's some phone calls to him where he did talk to his daughter a few times. But she's 7 years old. She doesn't know her address or where they're living. So I believe your order is appropriate. It was validly issued. It wasn't him hiding. He sent it to the address that the Clark County School District records show she was at. And she totally lied. She came back here for 2 months and didn't even have the courtesy of letting him see his kid for 2 months when she's back here, or let her even know he was back here. So I believe your order is appropriate, and when we have a full evidentiary hearing, then you can decide what's best for this child. But there's no reason the child shouldn't be given to him at this point in time.
Thank you. Ms. Shaw, this is Judge Hughes.
Hi.
What is your physical address?
My address is 18250 North 25th Avenue, apartment 2059, Phoenix, Arizona, 85023.
And how long do you intend to remain there?
I got a full-time job, so we're going to remain here for a while.
Oh, how long do you intend to remain in that apartment?
Oh, I signed a year's lease.
Beginning when?
I don't know when it began. I believe I signed it April.
April of 2018?
Yes.
All right. Did you have Mr. Taraki's written consent to leave the state of Nevada?
No, I never had his written consent.
Okay, thank you.
Have you heard?
Yes, counsel.
They're comparing credibility. When you look at his moving papers, it is replete with statements from the plaintiff that he had no contact with her, and that is an absolute proven lie. They were in constant contact. Their modus operandi is that he would email her and she would call him back. I have in my notes here a dozen occasions when that occurred. So all he had to do to get in contact with her was shoot her an email, and she called him back, and they were in constant contact. It's her position that he knew the whole time where she was, and he tricked this court by saying that he didn't know where she was and serving her by publication. That is false. And I see that the court is very concerned, and you're concerned that she moved out of the state without asking him. My understanding is that there was no action filed here, right? She doesn't need permission from him or anyone else to leave the court, to leave the state prior to the filing of any pleadings. I see the court disagrees with me on that, and I would love to hear your ruling on that, and I'm sure I will in just a second. But our point is that she was doing what she had to do. He had been supporting them. He cut her off totally financially. She had no choice, but she told him she's moving in with her father. She moved in with her father. There was no opportunities in Cleveland. She left Cleveland, got a job in Phoenix, was still in contact with her. She's done everything that she could to raise this child in a manner that's in her best interest. And there has not been a single fact adduced in this court, not one, that shows that it's in the best interest of the child to be with him. Not one. Everything is based on a technical ruling. I would submit that it is improper for this court to order a change in custody based on this technical defect when it's clear that there was abundant contact between the parties. Leave things the way they are, set it for an evidentiary hearing, and let's get to the bottom of it.
At what point did she advise him that she moved from Ohio to Phoenix?
When did you tell him that, Tashara?
We never received anything.
Alex sent me an email. It was March. He sent me an email, and I immediately called him on my lunch break to confirm with him and reassure him that where we lived and that everything was okay with us, because he was concerned.
Did you give him an address at that time?
Alex has known where we lived the whole time.
You're avoiding the question. Answer the question. When did you give him your address in Arizona?
I gave him our address in Arizona when I talked to him on the phone.
When?
March. It was the same day that he emailed me to call him.
Judge, if he knew her address in March and he got an order from you July 5th, he would have been down there picking up the child. That is so ridiculous for her to say he gave the address. There's no way that could possibly be true, especially since I asked Mr. Crawford for it twice. If we knew it, why didn't I get it? Why didn't they say here where it is? I mean, no, they didn't want me to know because they didn't want him going down to get the kid because they were hoping you'd change your mind and issue that. And there's nothing in our pleading saying he's never had contact with the child. There's on our pleading saying she left the state on December 1st. He's never seen the child, never had visitation. Yes, the child called him and he talked to him 3 or 4 times in 8 months. He's never known the address. We've never been given the address. If there was anything in her possession showing that, then we would have it. And like I said, in this Ohio thing, he talked to his dad 10, 12 different times, and his dad denied completely she ever lived with him. So, and they're completely not even mentioning the fact she came back here for 2 months. They're still saying she didn't do that. I mean, that is obviously a lie. We have the Clark County School District certified copy of the record showing she came back. And the address which we published to and served to was the one she gave. So that is the last known address we knew. Thank you.
Thank you, counsel. The court found that this is the home state of the child. And even according to defendant's own papers, the child remained here from, looks like June of 2014 to December of 2017. So this is the child's home state. Ma'am, where did you enroll the child in school?
She is right now.
Yes.
Right now, she is enrolled in Meadows Valley Elementary School.
In what grade?
She's in 2nd grade.
Okay. To answer your question, Mr. Crawford, under Nevada Revised Statute 125C.0015, parents have joint custody until otherwise ordered by the court. So even if an action had not been filed, because this is the home state of the child, This court has initial and continuing exclusive jurisdiction to make a determination on custody, but it says that the parent and child relationship extends equally to every child and to every parent, regardless of the marital status of the parents. And these parents were not married. Under subsection 2, if the court has not made a determination regarding the custody of a child, each parent has joint legal and joint physical custody of the child unless otherwise ordered by a court of competent jurisdiction. So, these parents, unmarried, had joint custody, and this is the home state of the child. And she left the state, the home state, without the written consent of the plaintiff or a court order. So, the child has to be returned here. Those are my orders. We will set a trial on the merits, but the temporary orders will stand. I don't find that the plaintiff has done anything wrong as far as service, but the court recognizes that a trial on the merits has to take place to determine the best interests of the child. But I also do not allow temporary relocations, because that adds another layer and another problem to the relocation trial, which I am assuming you'll be filing a motion for her to relocate from the state of Nevada to the state of Arizona, because there is no current court order or written consent allowing her to live in the state of Arizona with the child. And from the text message, I did see she quit her job and left the state.
She was making $10 an hour.
Well, still, she said she was unemployed. I mean, we're just showing she's not telling the truth, that's all. But
She
can we,
voluntarily left the state and didn't tell the plaintiff where she was living.
can my client
I
be,
submit to you that that's not true. She told the plaintiff she was going to her father's house, and he knew that.
There's an email to her in December saying, "Can I have the second half of Christmas?
Right.
What is the address?"
right, correct.
And I didn't see a response produced by your office, so apparently he didn't even know where she was. He thought she was in Ohio, but wasn't even sure where she was in Ohio. And she didn't tell him when she moved. She said she moved in January or February to Phoenix. She didn't tell him in January or February she's in Phoenix, and she never got his permission to leave the state.
We would ask if she'd be at her apartment tomorrow. Is tomorrow at 5 p.m. and he will be there to pick the child up?
Did you hear that, Miss Shaw?
Yes, I hear you.
Okay, he'll be there tomorrow at 5 p.m. to pick up the child.
Thank you, Judge.
And you'll meet at your apartment.
I'll prepare an order and submit it to Mr.
We have
Crawford.
a trial date.
It is.
I'm also sending you to mediation. You can participate by phone, Miss Shaw.
February 25th, 9
That-
a.m.
I'm sorry, Ms. Clerk.
February
I got it.
25th
Thank you.
at 9 a.m.
25th, 19, at what hour?
9 a.m.
9 a.m.
for a full day.
Thank you.
I'll prepare the order and send it to Mr. Crawford.
Houston, if you would, we're giving you a copy of the change of address one.
I'll give you what?
Just wait a minute, we're giving you a copy of the new address.
Oh, okay. Thank you very much.
How about
Yes, I
contact between mom and the child between now and February?
We'll be glad to arrange any visitation she wants anytime she's up here.
Well, I'm sending them to mediation, and
Right.
you can talk to counsel about immediate contact.
And
But the order needs to say that, it's still temporary. My
Right.
orders are still temporary, sole legal, sole physical, and he can enroll the
temporary
child in
sole
school.
legal and sole physical? On what basis?
Temporary, that's my order.
Right.
On
That
what?
was my order.
And I'll be
The
gl-
order from based on the default.
I'll be glad to work out with visitation for her. I mean, that's not even an issue. Thank you, Judge.
Okay, thank you.
Judge.
Thank you, Your Honor. Thank you, Ms. Clerk. Thank you, Mr. Martha.